Yes, Mr. Clear.
Lady, I'm coming to the end of my policy reasons, and then I'll go on to my third substantial submission in respect of receipt, and then my final brief submission in respect of agency. Before I do so, Lord Wilson asked a question in respect to the difference between summary termination and notice, and I averted that I'd come back to it in respect of notice, and I hope I dealt with it, but I didn't think I expressly dealt with my Lord's question, which was effectively in respect of short notice, where one has Parliament's intention, which I've dealt with under Section 86. If one has short notice, an example of someone employed less than 3 years, one may have, on the trust contention, one may have someone dismissed before they find out about the notice. And what's good for that short notice there's no basis for distinguishing between that short notice and long notice of 10 or 12 weeks. And my Lord, so there were 2 points I made in response to your question. The first one immediately was that one was dealing with termination of a contract of employment and what required termination. But the second point is that point in respect of notice. Lady, the next point I make about the contract of employment is that it provides for benefits. Benefits such as status, livelihood, insurances, company cars, pensions and other matters. And one needs, as an employee, to have notice of the need to replace those before termination. And unlike a lease for land, which of course has the huge benefit often of providing a home, unlike a lease for land, an employment contract does not touch or concern land. It is not about the land and landlord and tenant cases of service on land. The next point is that there is, in fact, no restriction when notice can be given. Unlike the ancient landlord and tenant cases, which my learned friend relies upon, where one has Lady Day, Michaelmas, Christmas Day, and Midsummer's Day, where one could only terminate leases on 4 days of the year, there's no restriction on termination of employment. Obviously, there has to be communication, but there's no restriction of the days. And we say in modern communications, it is possible in some cases, most cases, many cases, in order to communicate with the employee. And finally, in respect of the incidence of contracts of employment, is they can be terminated by notice, by written notice or oral notice. And we say it would be inconsistent on a policy ground that an employer might gain the benefit, if they can't communicate orally with the employee, they would gain a benefit by choosing one of the two methods, that is written notice, and merely sending it to a house and effecting it that way, in ways that they couldn't do so by oral notice. And consistently, we say there should not be a greater benefit. There should be a consistent treatment of oral notice, and oral notice is clearly only effective when communicated. And we say consistently with that proposition, they should be dealt with together. And then I deal with the final heading in respect of policy, and that's fairness. Firstly, we are dealing with a contract of employment, a private contract, and they can negotiate or have deeming provisions for service, as they did in Gaze. Secondly, notice is normally a surprise, it stands to reason, is normally a surprise to the person to whom it is given. It's not a surprise to the person who's giving it, and therefore it's right that communication should be required. Thirdly, in my learned friend's example of the dog or the plumber kicking aside the delivered notice, that in his case I think it's described as vanishingly small. It's only vanishingly small for those people who are lucky enough to have their front door as also the place where letters are delivered. For many people living in houses in multiple occupation or who share accommodation with others, that's not the case. And it can't be assumed, as my learned friend does, that the risks are vanishingly small. Fourthly, the chimera that we say the appellant raises in respect of the Googled small businesses going away. If one runs a small business, one normally runs it through agents. And not only does one run it through agents, when one goes away from a small business, a hairdresser, for instance, the chief manager or owner of the hairdresser will leave a manager who is the owner's agent. And notice served upon the agent is good notice. And in any event, for most people who run small businesses, they will keep in touch with their businesses. And in this age of communication, it really is a chimera that doesn't exist, we say, in practice. Fifthly, the example of dismissing and re-engaging large numbers of employees. Let's say hundreds or thousands. That's not done on a whim. It's not done on a whim by an employer who also has a holiday chart. So the employer knows who will or who is going away. And the employer can take steps by making sure that those who are going away, where the notice is ordinarily going to be sent out, should be notified before that, with their notice expiring on the same day as the others. Sixthly, the ostrich employee. And whatever this case is, this is not about the ostrich employee, the employee who either tries to ignore it or wishes to evade service. The implied term is a reasonable opportunity to find out. And finally, in 1980, those were the halcyon days when sometimes one couldn't be communicated, in some ways, one couldn't be communicated at all times. One couldn't be found, one didn't carry a mobile phone, one had to go to a telephone box, didn't have email, didn't have texts, didn't have WhatsApp with the double tick of communication, one didn't have Facebook, one didn't have all those methods of communication, and we live in 2017 in the age of communication. It's not an onerous burden in this relationship of the contract of employment, to imply a term that there should be communication before it is terminated. Lady, those are my submissions in respect to the policy reasons supporting the implied term, and of course they apply as well as to why they should exclude the implied term for which my learned friends contend. And so I move on to my third substantial submission, which is that Lady Justice Arden was right, that there had to be receipt of notice for it to be effective. And the presumption is properly that posting or delivery gives rise to a rebuttable presumption of receipt. It's not received until the employee accepts delivery of it. Now, the common law may presume receipt upon postage or delivery, but that can be rebutted. It was in this case by Mrs. Haywood, who opened the letter only on the 27th of April. And what we say with respect has happened is the appellant has sought, and with respect to Lord Justice Lewison, there is a reliance on a group of cases that are concerned with whether service was effected at all, not when the notice was served. And secondly, the cases are in respect of facts, which is why when one reads the short cases, one is concerned not with rules of law, but with findings in the most part of juries. And I divide my submissions up into four. Firstly, my learned friends, with respect to them, are wrong. The presumptions are not what they say they are. Secondly, it is important in the common law not to muddle or to let statutory presumptions infect the understanding of the common law. One must maintain a rigorous intellectual division between the two. Thirdly, they rely principally on a group of cases where there's receipt by an agent, not delivery. And fourthly, they rely on a group of cases which are received by a staffed business office during business hours. In respect of the presumptions, I can take them shortly by going, please, to the core volume 166. Paragraph 85. And the presumption, it's firstly important that my own friend doesn't contend for an irrebuttable presumption. He accepts his presumption is rebuttable. So when looking at each of these presumptions, we should also look at what needs to be rebutted. And taking firstly Water and Haynes, where a letter fully and particularly directed to a person at his usual place of residence is proved to have been put into the post office, this is equivalent to proof of a delivery into the hands of that person, because it's a safe and reasonable presumption that it reaches its destination. What's the destination, I ask rhetorically? It's not the address, it's not delivery through a postbox, it's into the hands of that person. And that's what stands to be rebutted. And then again at paragraph 86, if a letter is sent by the post, it is prima facie proof, until the contrary be proved, and here we have the rebuttable presumption, that the party to whom it is addressed received it in due course. It isn't a post box which it's delivered, it isn't an address, it's the party to whom it is addressed. And just looking at the terms of those two presumptions, you can see why Lady Justice Arden found the presumption was not as Lord Justice Lewinson said it was. And if there was remaining doubt about the presumptions, can I take you please to, over the page, paragraph 97. And this is the presumption set out by Lord Justice Edmund Davies. Based upon considerations, mainly, and my learned friend read this out, mainly of business efficacy, there is a long-standing presumption in our law that a letter duly addressed, prepaid and posted, which is not returned to the sender, has in fact been received by the addressee, unless he can establish the contrary. And what is he seeking to establish? Not, as my learned friend would have you understand, he's seeking to establish it wasn't posted through his letterbox. It was that it wasn't received by the addressee, because that's the presumption. In each of those three cases, in Walter, the presumption of receipt into the hands of someone; Warren, the presumption to whom the party it is addressed received it; Stidolf, the presumption that it's been received by the addressee, are all to do with receipt by a person and not by an address. The argument for the appellant starts off, we say with respect, misconstruing the presumption cases. And moving on to my second submission, we say it gets worse because what they allow themselves to do is to be infected by the statutory presumptions. They don't maintain the rigorous intellectual distinction that we urge respectfully upon this court. At paragraph 90, going back a page of Lord Justice Lewinson's judgment. At common law, where A wishes to give notice under a contract to B, the most that is usually required of him is to deliver the notice or cause it to be delivered at the recipient's proper address. We've addressed the presumptions, we don't accept that. It is ordinarily no concern of his whether B is at home to receive it. Thus, in Stevenson and Orca, Mr. Justice Scott accepted the submission that the time of delivery didn't effectively depends on when the postman arrived, and not whether the premises are occupied or empty. But what Lord Justice Lewison is doing and what my learned friends are doing is they're mixing their common law presumptions with statutory presumptions. And what one needs to do is go to Stevenson and Orca in volume 2, tab 40, 1062. Volume 2, tab 40, 1062. K. And Mr. Justice Scott sets out at tab 40 of volume 2, 1062K, section 1964 of the Law of Property Act 1925. And I just want to take you to the last, if you see in small type, just below the letter K. And that statute contains a presumption, and that service shall be deemed to be made at the time at which the registered letter would in the ordinary course be delivered. So there's deeming on delivery. understanding that that's the presumption with which Mr. Justice Scott is concerned, one then goes to the top of page 1063 by little g. The time of delivery in the ordinary course of post could not, he submitted, depend on whether or not the premises to which the letter was addressed were, when the postman arrived, occupied or empty. I agree that this must be so where the ordinary post is concerned. Mr. Justice Scott is making a factual conclusion about the time of delivery. He isn't, as Lord Justice Lewinson appears to be, and as my learned friends appear to contend, he isn't making any judgment as to what's required under the common law or whether delivery is presumed. What's happened here is a mistake of infecting the common law approach with the statutory approach. And I urge you not to do it. There is one case I'm going to take you to where Lord Justice Ricks analyses the difference, and that's helpful, but otherwise one should be careful. And perhaps I can exemplify that by the case of Wilderbrook, which my learned friend also relies upon. And this is to be found in volume 3, tab 52, 1246. Volume 3, tab 52, 1246. And it may be, my lady, that we'll submit the case, the decision below, because I don't think, in a way, interestingly, what Wilderbrook doesn't do, at paragraph 28 on 1246, it sets out, the judgment of the Court of Appeal sets out, clause 8 of the lease incorporates statutory provisions as to service. So it wasn't found on the common law, it was these statutory provisions as to service, and in fact they were Section 196 of the Law of Property Act. It's not clear from the judgment, I couldn't find it, had to read the judgment below. But perhaps if we can provide that, again, it shows the difficulty of using these statutory cases to try and draw conclusions or inferences as to what the common law means.
Sorry, Mr. Glynn, what was the statutory provision?
196 of the Law of Property Act, the one, my Lord, that we've considered in Stevenson and Orca.
Okay.
Those are my first two more general points about the approach. The third and fourth submissions are to distinguish the cases on which my learned friends rely. And firstly, in truth, Neville and Dunbar is a case about agency, as is Griffiths and March. And if one can turn, please, to volume 2, T30, 923. Now, and this is where the attorney went to the house on the 22nd of March, served 2 copies on a notice to quit, one on the servant, the other on a lady. The attorney was told that the defendant would not be there until the 26th of March, and the notice to quit was on Michaelmas. It was attempted to show that both the lady and the servant on whom the notice was served were dead. Now, the learned friend said that they were both dead, but it appears that the court found that reports of the servant's death had been greatly exaggerated. Because if one looks at the judgment of Lord Abbot, Chief Justice, I have no doubt that the service of the notice was sufficient. The question does not arise here, for the servant might be called. Of course the notice was sufficient, because the servant was there to receive it. The tenant had said, well, the servant was dead, and it was proven clearly the servant wasn't. And as his agent, he'd received it. So, of course, the notice was sufficient. The next case, Griffiths and March, is also, and this can be, this is volume 1 of the bundle of authorities, tab 22, the last tab, 838. And over the page at 839, we say it's necessary to have a look at Mr. Justice Buller's findings to interpret properly those made by Lord Kenyon. And he starts on the first line, then what were the facts of this case? It was proved that this notice was delivered to the tenant's servant at the dwelling house of the tenant, and its contents were explained at the time. And that servant, who is in the power of the defendant, was not called to prove she did not communicate the notice to her master. This was ample evidence on which the jury would have presumed that the notice reached the tenant. And again, it's a case, we say, as it can be seen, it was serviced on the agent, and that was received. Going back to the comments of the judgment of Lord Kenyon, where he holds this is different from the case of personal process. And I'll take you in a moment very briefly to the case of Tyne, where one can see Lord Westbury explain that comment. This is different from the case of personal process, but even in the case alluded to of service on the wife, I do not know that it is confined to service on her on the premises. I believe that it be served on her in the house, that it's sufficient, but in every case of the service of a notice, leaving it at the dwelling house of the party has always been deemed sufficient. Now, that may be the case in respect of land, but clearly we say the articulated reason of Mr. Justice Buller is it was service on an agent who wasn't called to rebut that. And indeed, if I can take you, please, to volume 2 of the Bundle of Authorities, tab 42, 1084. And two-thirds of the way down, Lord Westbury expresses this in respect of Jones and Marsh. In the original case of Jones and Marsh on 1084, in the original case of Jones and Marsh, Lord Kenyon lays it down as beyond the possibility of dispute that in every case the service of a notice by leaving it at the dwelling house of the tenant has always been deemed sufficient. Now, I've already explained if one looks at the case and sees Mr. Justice Buller, it appears to have been concluded on the facts. However, Lord Westbury goes on, but he qualifies that by explaining that he speaks of notices affecting property as notices to quit, and not those notices which are intended to bring an individual within personal contempt. Now, I'm not saying that
Can you unpick that Delphic phrase for me?
As I unpick it, I rely on, and it perhaps it wouldn't surprise you, my lord, I rely really on the first part before the paragraph, before the comma, yes. In that it's a notice affecting property. In respect of notices intending to bring an individual within personal contempt, I accept he seems to be referring, does he not, to committal proceedings,
Sounds like it. Yeah.
Those types of things
Yeah.
which he must do. But he is limiting it. What he's doing is, there may be a grey area between, my lord. And there may be a grey area, but he is limiting it. He is limiting whatever one can take from Lord Kenyon, we say, to notices affecting property. And as I say, I rely on Mr. Justice Buller to properly analyse the ratio of that decision. It's a case, we say, about receipt by an agent. Fourthly, the line of cases based on staffed offices in business hours. And keeping in volume 2, can I take the court, please, to tab 31, 925. And the remarkable case where posting in the morning would lead to delivery in the morning. As you can see at the bottom, the learned judge left it to the jury, it's a question of fact, to say whether the letter arrived at the chambers of the, at the bottom of 925, I beg your pardon, to say whether the letter arrived at the chambers of the plaintiff's solicitors on the 25th of March after business hours or upon the morning of the 26th. The jury found that it arrived on the 25th after the plaintiff's solicitor left the chambers, and the plaintiff's solicitor said he'd left at 6 or 7. They said that they thought he ought to have had somebody there to receive it. And what this is one can see from the opposite page, from the decisions of Baron Bramwell and Baron Wilde, 1287. When the jury say that in their judgment the agent should have had someone in his chambers at the time the notice arrived at, they in effect said arrived within the ordinary business hours. And rightly so, one should be taken to have received it. Below that, Baron Wilde, last 2 lines, the jury have found that the notice arrived at the agent's place of business at a time when someone ought to have been there to receive it. Again, we say the majority of the court is indicating that where you, as a matter of fact, deliver a notice to someone who has staffed offices which are in business hours, which is what effectively the jury found, then there's receipt, and you can see that in the next case of the Brimness. And that's, we say, the prism through which Chief Baron Pollock's decision has to be seen. It is a finding of the jury that this letter arrived during business hours and the agent should have had someone there. And can I then take you forward, please, to tab 43, 1105. Tab 43 in the same volume, 1105. And this was a case that, on which Lord Justice Lloyd relied upon, the Brimnets, and it was a case between 2 commercial organisations. And we say the facts of the Brimnets at 1105H give the appropriate prism through which to interpret the comments of Lord Justice Magore on which Lord Justice Lewison was to rely in this case. And what he says of the person of the party on whom was to receive the telex was this. There was, 4 lines up from the bottom on 1105, there was on the other side the important evidence of Mrs. Sayce, a responsible member of the Charterers staff, who was in charge of their telex machine, which was never switched off. She testified on the 2nd of April, it was after 6:30 p.m. when she went home, that before leaving, she would have checked the telex machine, and that it was not until the following morning that for the first time she saw the withdrawal telex on the machine and took it straight to Mr. Sanders. As it happened, the judge made findings that the telex was sent between 5:45 and 6 o'clock. But if one goes forward to 1127, one sees Lord Justice Magore's proposition at the bottom at H. With all respect, I think that the principle which is relevant is this. If a notice arrives at the address of the person to be notified at such a time and by such a means of communication that it would in the normal course of business come to the attention of that person on its arrival, that person cannot rely on some failure himself or his servants to act in a normal business-like manner in respect of taking cognizance of the communication, so as to postpone the effective time of the notice until some time later when in fact it came to his attention. Bravo, we say, that's right, and that's obviously right in the case of commercial charter parties, staffed business offices, is that if you send an email within business hours to someone else or communicate with them during business hours, then receipt might be held during those business hours when those staffed offices are open. But it is not applicable to an employee who goes away on holiday at a time when the employer knows that she's going away on holiday on the findings of His Honour Judge Rayside. And we simply say to try and apply the Brimnes to the facts of this case are for the reasons said better than I can by Mr. Justice Bean at paragraph 17 of Guy de Cuff in the Employment Appeal Tribunal. That it's simply not appropriate when we're dealing with an employee who goes away from their home on holiday to import some kind of charter party, office, staffed business offices rule, as one did in the Brimnes. And so, in moving towards the conclusion on receipt, I move back to the core bundle and to 178. And what Lady Justice Arden does at 178 is introduce Freetown and Asset Hold, a case about Section 7 of the Interpretation Act. Now, for my part, I have urged and still urge this court to maintain a rigorous intellectual distinction between the statutory presumptions and the common law presumption. But the reason why Freetown is important, because if one goes to paragraph 37, quoted fully by Lady Justice Arden, what Lord Justice Ricks does is he analyses a distinction between Section 7 and the common law. It may be observed that Section 7 is a complex alteration of the common law rule which requires receipt to effect service. Exactly. Instead, Section 7 deems service to be effected at the time the posted document would be received in the ordinary course of the post. The difficulty for my learned friends is effectively they're contending for a rule of the common law which is the same as Section 7 of the Interpretation Act. One asks the question, why perhaps then was Section 7 ever needed? But what Lady Justice Arden does in relying on Lord Justice Rick's analysis here is to show, in the example of another justice of the Court of Appeal, that there was a difference, there was an alteration of the common law rule, and the alteration was between receipt, as required by the common law rule, and deemed service, as set out in Section 7 of the Interpretation Act. And at the end of that paragraph, Lord Justice Ricks says, the ultimate formula, however, is to maintain that part of the common law rule which requires receipt, but to deem receipt to take place when would the letter be delivered in the ordinary course of post. And so clearly saying that for what my learned friends contend is different from the common law rule. My learned friends wish to have Section 7 of the Interpretation Act apply to all contractual terminations, including contractual terminations in the special and particular circumstance of this class, the contract of employment.
But what does receipt mean in paragraph 37?
If I can answer that firstly by saying what it doesn't mean, and then I'll go on. I say plainly what it does mean. What it does mean is receipt into the hands of someone, or as the presumptions I've set out, receipt by the addressee, receipt into the hands of someone in Warren, or receipt by the person to whom it was intended to deliver, as in Walter. That's what receipt means, as one can see from the common law presumptions. But whatever receipt does mean, it clearly does not, as my learned friends contend it does, that it means deemed posting. It doesn't mean that it is deemed to be effected at the time the posted document would be received in the ordinary course of post. So I suggest, as I've just done through the three presumptions, what receipt means. But whatever it means, it doesn't mean what my learned friends contend it for it to be, because, as Lord Justice Ricks analyses, it's different. It's different from the common law rule, which only deems service to be effected at the time the posted document would be received in the ordinary course of post.
How clear is it that he means receipt into the hands of the recipient rather than receipt at his address?
My Lord, from those short words, I accept it isn't. I don't contend otherwise. Simply what I do is, what I rely upon is the foundations of my argument made earlier as to what receipt is. I accept, my Lord, that one can only go so far with the comments of Lord Justice Ricks, and I don't say that they certainly don't in any event bind this court, but they do serve as a useful bolster as to why Lady Justice Arden understood and analysed receipt in the common law as being different from deemed delivery. And I do no more than pray them in aid of why she was right to reach her conclusion. If I can then finish this part of my submission at paragraph 147, 182 of the core bundle.
Sorry, page.
182 of the core bundle, my Lord, paragraph 147. And Lady, the court will have read this, and simply I repeat it in terms of Lady Justice Arden's conclusion. And also to note that she knows that her conclusions as to service would reach the same conclusions as my submissions in respect of the implied term. And I say, she describes Brown and Southall and Hindle, Gears and McGinty as the law applicable to contractual dismissals. Which again, I say, supports my implied term. And the final judgment of Lady Justice Arden, the final conclusion, is to be seen 5 lines down in paragraph 148.
Well, Mr. Clean, at some stage, are you going to, you can argue everything in the alternative. You have a rather complicated forensic situation in which you were successful as a result of 2 conflicting decisions about what's required. Are you going to say which one you actually contend for, or are you going to leave it fluid?
The implied term, my Lord, is very much our primary case.
No, but I mean actual communication, or see the envelope. Take possession of the envelope, Lady Justice Arden, read it, Mrs. Justice Proudman. Which is it?
My Lord, it's communication of the letter or a reasonable opportunity of doing so. That's simply what it is. It's the Brown formulation. And whilst Lady Justice Arden may have said, accept delivery of it, it's accepting delivery of it or having a reasonable opportunity to read it, to find out about it. The Brown.
Aren't you saying it's the Brown test, either actual communication of the contents of the document or a reasonable opportunity of for the intended recipient to read it? I thought that's what Brown says, doesn't it?
Yes, Lady, yes. And I accept that if one stops purely at what Lady Justice Arden says, that is only to accept delivery, that may be too constricting because one needs the reasonable opportunity to read it as well. So, for instance, the person who is attempting to avoid service or the ostrich employee. So I accept that. That's capable of making it too onerous upon the employee. And so there has to be the temper. On the employee? The employer, I beg your pardon, yes. Lady. There has to be the temper, and the temper is the wording in Brown, a reasonable opportunity to read about it. If I can just briefly then go to the agency arguments. Lady, as I said at the beginning, the first time this argument was found was in the judgment of Lord Justice Lewison, and my learned friend took you in Appendix 2, page 261, MS, Memory Stick 389. So Appendix 2, page 261, MS 389. And my learned friend read out the relevant parts. simply this, is that the Trust didn't put the matter in issue at trial. We don't know what Mr. Crabtree said to the post office. We don't know why the post office released the letter to him. There are no facts to support the fact the post office might have believed that Mr. Crabtree was Mrs. Haywood's agent. We have none of those facts from Mr. Crabtree on the picking up of the letter and the contended for agency. So it simply isn't, as Millen and friends contend, an arid distinction, an arid point, which could or should have, which shouldn't have, or doesn't matter whether it was explored below. It should have and it could have been. And it's unfair, we say, with respect, to take this point now when it wasn't explored below. But more than that, we say that Millen and friends submissions as to plant pot agency are simply that. They are a stretch. The whole point about the agency relationship, we say with respect, is to bind the principal when the agent interacts with third parties. If within the own domestic world the agent writes a plant pot, there's no interaction with third parties. It's a domestic situation. It's not like a case I'll briefly take the court to in Clark, where one's interacting with third parties. There's no case of Mr. Crabtree being authorised to deal with Mrs. Haywood's employers. There's no case of Mr. Crabtree being authorised to enter contracts or do such like. What he was charged with, as one can see from 389261, was simply to look after domestic matters, internal matters, tidy away the post. And it would be a strange agency, I say, rhetorically perhaps at paragraph 6, that where the agent picks up the letters but does not open the letters because they aren't addressed to him. And that may, if there is an agency, show that it was restricted not to post. His job was simply within the domestic sphere to put them from the post, from the doormat, onto the sideboard. And as one can see at paragraph 8 of his statement, he decided on a course of conduct of his own later to be helpful and go and pick up the letter. We say it would be an unfortunate extension of the law of agency into this area of the volunteer family helping within purely the domestic sphere, which is what in truth this is.
But, I mean, as the arguments have developed in this court, where does agency come in, actually, Mr. Glynn?
Well, I don't want to...
I mean, if Mr. Kavanagh is right and it's delivery, then agent or no agent, this letter was delivered on the 26th. End of story. If you're right, actual communication, well, there's no actual communication to Mr. Crabtree. Reasonable opportunity to read it. Nobody is suggesting that Mr. Crabtree should have opened it and had a reasonable opportunity to read it. So where does it come in?
Well, as I understand the case made for the Trust, it comes in on the point that they say delivery to the agent on the 26th, Mr. Crabtree, qua agent, was good delivery, good service on the 26th.
I thought it was delivery to the address.
Well, they are saying that. I don't wish to advance Millen and friends,
No,
but they are saying that. But like the agency cases I took you to, which were where one handed it to the servant, delivery to the servant was good service on the principal. And what they're saying is that in the same way, Mr. Crabtree was the maid servant to Mrs. Haywood, and therefore service on the agent bound Mrs. Haywood. That's the way in which Lord Justice Lewinson advanced the proposition in his judgment. And
I thought Mr. Justice, Lord Justice,
I beg your pardon.
said that the agency point was irrelevant to his disposal. Anyway, we can read it for ourselves.
My Lord, if I can then deal with the final point in respect of agency, and that's also Lord Justice Lewison held that if Mr. Crabtree wasn't empowered with agency, it was a ratification of his agency that Mrs. Haywood opened the letter and read it. And simply what we do is we rely upon Chitty, which we've handed up this morning, for which apologies for the fact it's not included. There are two parts. At Chitty 32nd edition, starts 31027, agency. Headed agency, the lady. And at 31028, ratification will be implied from any act showing an intention to adopt the transaction, including commencement of or pleading in an action at law on the transaction in question. And we make the short point. When Mrs. Haywood arrived home in the early hours and then opened the letter at 8 or 8:30 in the morning before she saw Mr. Crabtree, there can be no implication from her act in opening the letter of ratification. She simply opened a letter waiting for her. It was as simple as that. There wasn't an election or a choice. Secondly, knowledge of circumstances over the page at 31030. It is often said that a person ratifying a contract must, at least in order to be bound, know fully of all the material circumstances in which the act is done. So a principal does not ratify a wrongful distress by receiving proceeds of it until he has full knowledge of the wrongful act. And of course, again, Mrs. Haywood opened the letter before Mr. Crabtree attended at her address, and there's nothing to be said from opening her letter that she knew the circumstances in which the letter had arrived at her house. So there was neither the election that's required for ratification, nor was there the required knowledge for ratification, and therefore the agency, the proposition of agency, we say, fails. Which leads to 2 points before I conclude my submissions. Firstly, can I take, Milady, can I take the court, please, to Clark at volume T, tab 25. Sorry, volume 2, tab 25.
Give her a page.
861. And this is at 861 F to G, and it's the, or if one starts a bit above F, is what happened here is a letter was written on the 5th of March that asks for Mr. Clark's explanation of his absence in Jamaica. The second, a week later on the 12th of March, said that if no reply was received within 14 days, it would be assumed that he did not wish to continue in the employment of London Transport. And then if we can drop down to the next paragraph, although he did not reply, his wife did. On the 18th of March, she said, "My husband don't intend to give up his job. He will be back for his job in April. Please be lenient to us." And then coming back up, the 3rd, so this letter now is after the 18th of March, just before the paragraph, the 3rd, a fortnight later, saying his name had been permanently removed from the books. Now, as my learned friend is right, this is a case about the elective termination of a contract of employment. It isn't about when service was affected. But in any event, if one goes to 868, the judgment of Lord Justice Templeman, 868G, after 1 month had elapsed, the employers decided not to allow the employee to resume his work if and when he reported back, and they wrote to the employee informing him of their decision. The employers thereby determined the employee's contract of employment, and the question for the tribunal was whether he had been unfairly dismissed. But that isn't all that Lord Justice Templeman said about the communication. He said over the page at 870 F, and this was effectively the accepting of a repudiation by the employers. In my judgment, a finding that the employers either on March 26, 1979, when they removed the employee from their books, or on the date when their letter reached him through Mrs. Clark, or thirdly, which is my learned friend said this was the only principle, was found by him when he returned finally from Jamaica. And what Lord Justice Templeman was saying there was that you have Mrs. Clark writing to the employer, perhaps being an agent, or maybe not being an agent in the doctrine of repudiatory breach. She was conveying to him on his finding the fact of the employer's letter to them, one of three ways. And in any event, this wasn't an authority on when notice was effected, but other questions were in play. The final point I wish to make is a point my learned friend made as to the building blocks on Chitty. And this is the second part of Chitty, which we handed up. And simply, my learned friend said that it was an absolute rule. It was one of the building blocks of contract, absent of contract, and therefore it should be subject to absolute rules as in termination. But if one looks at the operation of the postal rule on the second page of Chitty at 2052, can I invite Lady of the Court to read that? It isn't the absolute rule for which my learned friend contends. And, my lady, for those reasons, we say that all roads, the implied term based on Gay's, the contract analysis of Brown and McMaster, the repudiation analysis of Edwards and George, the dismissal analysis of Hindle, Gears and McGinty, and the analysis of Lady Justice Arden on receipt, lead to the same conclusion. And that conclusion is that there must be communication of the dismissal or a reasonable opportunity for the employee to read of that. And we say what can be fairer, more just and reasonable and necessary than that in this age of communication and on the facts of this case. And the safety valve of the implied term of reasonable opportunity, or by the drawing of inferences against a receiver, or by preventing someone who tries to avoid receiving a notice to stop them from denying that, is a proper qualification on the implied term or the term of receipt. And for those reasons, my lady, we say this appeal should be dismissed.
Thank you, Mr. Glynn. Mr. Brown? Mr. Kavanagh.
My lady, my lords, may I ask you to turn to the Statement of Facts and Issues at page 71 of the memory stick. My learned friend is wrong, with great respect to him, to say that the facts upon which this court should operate was that the trust knew full well that Mrs. Haywood would be away in Egypt when the letter arrived on her doorstep. In fact, at paragraph 15, the Statement of Facts and Issues, the facts are set out as they were accepted to be at the Court of Appeal. At the time that notice of dismissal was issued, the Trust was aware that Mrs. Haywood had booked annual leave and was going to Egypt, but was not aware of the dates when she'd be out of the country or what arrangements she'd made for collection of her post whilst she was away. It is right that the first instance judge made inaccurate and mistaken findings of fact based on a misunderstanding of the undisputed evidence. That was sorted out in the Court of Appeal, and just for your note, that the correct understanding is referred to by Mrs. Justice Proudman, paragraph 35, MS 155. So this is not a case which the employer sent the letter knowing there would be nobody there to receive it. My next point is this, that in light of the questions from my Lord Wilson a few minutes ago, it's clear that my learned friend is submitting that the implied term is that notice is given, not necessarily when the individual sees the document, nor even when the document comes into the individual's possession, but when she or he has a reasonable opportunity of finding out. We respectfully submit that's a recipe for uncertainty, demonstrated by the fact that in this case, all three judges took a different view of the point at which notice should be given, and two of them, Mrs. Justice Proudman and Lady Arden, might have been understood to be thinking along the lines of when a reasonable opportunity to have accepted notice had taken place. In our respectful submission, therefore, the implied term my learned friends seek to invite you to adopt reinforces the sheer uncertainty that matters would be left in. next point, I'm sorry to rattle through them, but my next point is this, that my learned friends focus upon a case in which the employee is away to the employer's knowledge. I've already submitted that isn't actually the facts of this case. But in the real world, that's very unlikely to happen because there is nothing, no benefit whatsoever for an employer to send notice to somebody who's not there to get it. There simply is no advantage in law for an employer doing such a thing. The much more likely issue, and the problem that, with great respect, my learned friends haven't addressed, is that their argument must also apply even if the employer is wholly unaware of the employee's absence. All the employer knows is the home address the employee has given to the employer, and in those circumstances, why should the employer lose out if the employee happens to have gone away, as is their right?
That argument cuts both ways, because your argument applies even when the employer knows perfectly well.
It does, indeed. But my submission, my lady, is that in reality, the difficulty my learned friends face is much more likely to arise than the difficulty I face, because there is actually no benefit to an employer under any circumstances to give notice to somebody knowing that they're not there to receive it. There is simply no advantage. As for the authorities, my learned friend very pleasantly and amiably submitted that I was stirring up uncertainty about what the earlier cases say. With great respect, that uncertainty was stirred up, if it has been stirred up, by Lord Justices Lloyd, Mummery and Kennedy in Gisdekiff and Lord Justice Lewison in this case, because they are the judges upon whom I primarily rely for our submission, that the common law has been as I submit it has been. I don't have time to take you through the authorities. May I just mention one thing, that in Papillon and Brunton, which is volume 2, tab 31, MS 927, my learned friend relied upon the very short judgment of Baron Bramwell in support of the proposition that delivery is only sufficient if it happens in working hours. In fact, Baron Bramwell went on to say, I doubt whether, in the absence of any express limitation by the agent, it is necessary that the notice should be given within the hours of business. So in fact, his conclusion was that arrival outside the hours of business was effective service, just as arrival during the hours of business. My lords, my ladies, I should say that as we understand my learned friend's submissions, if we may say so quite rightly, they don't try to rely upon the law on EDT, the statutory case law, as necessarily reading across to common law. Where we say they go wrong is that the three groups of cases that my learned friend relied upon in the first part of his submissions, which he said were contract cases, are actually all statutory cases. So Brown and Southall and Knight, McMaster, without exception, they are repudiatory cases, and with one exception I'll come on to, they were all about when the effective date of termination took place. Brown, for example, was an effective date of termination case because that's what mattered for whether the claimant had the necessary 26 weeks in order to bring his claim. McMaster's, similarly, a time limit case. The exception is Hindle, but the Hindle case, which was the case about whether somebody had been dismissed before industrial action started or during the course of industrial action, was not a case about when notice took effect. Hindle was a case about a prior question, which is whether you have to give notice of termination at all. And one sees that at page 777D. So Hindle is a case, the only one, about the common law, but it's not a case that raises the common law issues with which we are concerned. Very finally, on the public policy issues, we respectfully submit in the vast majority of cases, a claimant is going to know about notice and will know about notice well in advance of termination, as was the case, of course, in the present case. In the present case, Miss Haywood was, on her case, only a few days at most behind the curve and more than 11 weeks before her notice expired. It's actually only going to be a problem in the very rare case of somebody who has one, very short notice, a week's notice or so. Two, they're away for a long period and uncontactable. Three, they have no idea it's coming. In the present case, Miss Haywood knew that she was very likely about to be made redundant. And fourth, they have no arrangements for anybody checking their mail whilst they're away. Now, I accept that there will be cases, may well be cases, where that happens, but not very many at all. And we respectfully submit that shouldn't sacrifice the interests of certainty for these very rare cases. Finally, multiple occupation house, that's not a problem because it's only if it arrives at your flat that it counts as delivery. It's the same as the answer that Lord Justice Lewison gave to something blowing away on your doorstep. If it doesn't get to your house in the first place, or your home, if you live in a block of flats, then it's not been delivered to you.
What if you live in a block of flats where there are post boxes?
Then it's your post box, yes. But that's not what I understood my learned friend's concern to be about. It was the shared houses where you often have a mantelpiece in the hallway where everybody's letters are dumped. And in those circumstances, in our submission, it would only be when it gets into your flat that there would be service.
Why is the mantelpiece any different from the post boxes in the hall?
Well, because the
Seems
post
very
box in the
similar
hall
to
is your own post box. The mantelpiece is the communal mantelpiece. In any event, my lady, that's my submission.
It's not going to resolve the case, is it?
One hopes, or at least I hope it won't resolve the case now. The presumption cases, we say the three cases that are the strongest for us on presumption are Stidulph at 1069, that's tab 41, Stevenson and Orca, tab 40 at 1063, and Wilderbrook, which is tab 52 at 1238. My lady, my lords, my lady, those are my submissions.
Well, we're very grateful to you. We're very grateful to everybody for their submissions, which we shall go away and consider with great care, and we will let you know how we propose to answer it, hopefully, at least in a way where there will be a clear ratio to the decision, whichever way it goes. Thank you all very much indeed. The court is now adjourned.